All right, I'm going to call to order the meeting of the Sentencing Guidelines Commission. Today is June 6th, 2024, and I will ask our Director, Nate Reitz, to take the roll.
Roll call. Vice Chair Larkin.
Present.
Larkin present. Commissioner Crutchfield. Commissioner Crutchfield absent. Commissioner Fraze.
Present.
Commissioner Fraze present. Commissioner Knutson. Commissioner Knutson absent. Commissioner Ladd.
Present.
Commissioner Ladd present. Commissioner Middlebrook.
Present.
Commissioner Middlebrook present. Commissioner Moore.
Present.
Commissioner Moore present. Commissioner Morin.
Present.
Commissioner Morin present. Commissioner Mueller.
Present.
Commissioner Mueller present. Commissioner Reeves.
Present.
Commissioner Reeves present. Commissioner Saxena. Commissioner Saxena absent. Chair Mitchell.
Present.
Chair Mitchell present. Madam Chair, there are 9 members present, 3 members absent, 1 seat vacant.
All right, so with that, we have a quorum. First item on the agenda is approval of the draft meeting agenda. I would entertain a motion to approve.
So moved.
Commissioner Larkin makes that motion and Commissioner Middlebrook seconds. Any discussion on the agenda?
She got it.
She
Okay.
did. She did.
That's
I saw
fine.
her hand.
You looked at me and said Middleburg. I just wanted to clarify. That's fine.
You were both up there really fast.
That's fine.
Any discussion on the agenda? Hearing none, we'll take the vote.
Do the Larkin motion to adopt the meeting agenda. Larkin?
Yes.
Larkin, yes. Crutchfield? Crutchfield absent. Fraze?
Yes.
Fraze, yes. Knutson? Knutson absent. Ladd?
Yes.
Ladd, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morin?
Yes.
Morin, yes. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena? Saxena absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
With that, the motion is approved unanimously. Next item is approval of the draft meeting minutes from May 9th, 2024. You should have all had time to review these as they were sent out last week. I would entertain a motion to approve the minutes.
So moved.
Commissioner Larkin makes that motion. Commissioner Ladd seconds. Any discussion on the motion? Hearing none, we'll take the roll.
To the Larkin motion to approve the May 9th, 2024 draft meeting minutes. Larkin?
Yes.
Larkin, yes. Crutchfield? Crutchfield absent. Fraze?
Yes.
Fraze, yes. Knutson? Knutson absent. Ladd?
Yes.
Ladd, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morin?
Yes.
Morin, yes. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena? Saxena absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
With that, the motion is approved unanimously. Next item on the agenda is sentencing guidelines changes related to the 2024 regular session laws. It's an action item. I'm going to turn it over to Director Reitz.
Thank you, Madam Chair. So we have really 2 documents related to this session. Sometimes we'll have them all in one agenda item, but we thought to conserve time, we would put the action items up front, and the remainder of the documents are part of the Executive Director's report at the end of the meeting, assuming we have time to get to that. And those are the legislative items that are for your information that we anticipate the Commission would find interesting, but we do not anticipate the Commission would need to take any action. So that's why those are at the end, as opposed to being in an action item. I'm going to display my screen here. So this is this is a document called Possible Modifications to the Sentencing Guidelines and Commentary. And we discussed this last month, you may recall. We sort of did some preparation work last month, which hopefully will make this a little bit shorter. But basically the legislation, the 2024 legislative session is over, and the Commission at the end of every session reviews crimes created or amended by the legislature in the preceding session to see if there's any possible related modifications to the sentencing guidelines. And under the modification statute, which is subdivision 11 of your charter statute, you have the authority to make modifications that are related to crimes that were just created or amended by the legislature in the preceding session, effective immediately. So these do not have to be submitted to the legislature in advance. You have to report them afterwards, but you have the authority to just make these changes effective immediately. But there is a public hearing process that has to occur. So that public hearing process is going to occur next month. There's going to be a public hearing. I don't have the dates in front of me. If anybody can help me out, I'd appreciate that. But there's going to be a public hearing in July 18th, you said? 18th. And then a week after that, on July 25th, there's going to be a meeting. And those have to be two separate dates. The public hearing, it is not required that a quorum of the commission attend. The chair has to be there to run the meeting, but a quorum is not necessary. We'll hear from the public on any feedback on any of the decisions that the commission makes here today. And then you'll meet a week later to take final action. So every change that you adopt today to the sentencing guidelines is understood to be a preliminary motion to adopt the change subject to the public hearing and subject to final adoption. And we need to fit that in before August 1st. So that's why we have kind of this interesting schedule, because August 1st is the day that most of these changes take effect. And so we try to coordinate the annual edition of the sentencing guidelines with the changes in it for publication on August 1st.
I'm gonna just pause there for a sec. I want the record to reflect that Commissioner Knudsen has joined us.
Thank you, Madam Chair. So we talked about assigning severity level rankings in general at the last meeting. So really not going to rehash that other than to say that we're looking at the level of harm typically caused by the offense and the typical culpability of the offender that's described in the elements of the crime. We also look at other statutory maximum penalty that the legislature set, although that's not something that the commission has to be bound by. How similar offenses are ranked. Alternatively, the commission always has the option to leave the offense unranked. Unranked offenses typically have those three characteristics. They're rarely prosecuted. They cover a wide range of underlying conduct, or they are new. And obviously all of these are new. Well, most of them are new. And the severity of a typical offense cannot yet be determined. So that's the main decision, is what severity level should be assigned. There's some other decisions as well. Should the offense be added to the offensive list of offenses eligible for permissive consecutive sentences? That list has historically been a list of crimes against the person. So that's really historically been the sort of the guiding principle of adding things to the list. So the idea is if you have, if the defendant committed 2 crimes against the person, the judge has the authority, following the rules for permissive consecutive sentencing, to sentence those 2 crimes consecutively to each other. Another issue is, should the offense be added to the list of severe violent offenses? That's a very small list. Those really are severe violent offenses. And we don't have any recommendation. Staff doesn't recommend changing the severe violent offense list this year. And are there any other modifications that have to be made to the sentencing guidelines? So the first offense, we talked a little bit about this last month. This may be the only offense that actually is on here that we talked about last month. So this is transferring firearm to ineligible person. There's an existing crime that's amended, an existing felony, I should say, that's amended. And then there's a new felony that's being created. It used to be a gross misdemeanor, now it's a felony. So there's really 2 different crimes to be looking at here, 2 different ranking decisions under transferring a firearm to an ineligible person. So this law did a couple of things to 624.7141, transfer to ineligible person. The first thing it did is it elevated that gross misdemeanor to a felony with a statutory maximum of 2 years imprisonment and a $10,000 fine. That's a pretty low statutory maximum. It's 1 year would be the sort of the entry level for being a felony. It is 2 years and a $10,000 fine. So just reading that, I would say that's not a legislative signal for it being terribly severe. The the elements of the crime are changed. So in addition to elevating it from a gross misdemeanor to a felony, it also changes it in a couple of ways. One is it expands the weapons that can apply. So under the current gross misdemeanor, it only applies to, and by the way, this is kind of called straw purchasing. That's the colloquial name for this. So somebody's buying a weapon basically for somebody who's ineligible to buy a weapon. So they're not the real purchaser, they're the straw purchaser for the real purchaser, who's the ineligible person. So the current offense is limited to the transfer of a pistol or semi-automatic military style assault weapon. The new crime, though, this new felony, is expanded to encompass the transfer of any firearm. And the current offense requires the defendant to know that the transferee is ineligible. The new crime is met if the defendant either knows that the transferee is ineligible or should have known or reasonably should have known of the transferee's ineligibility. So it really relaxes really two elements. One, the firearm element and the knowledge element are both relaxed, but the severity is increased from a gross misdemeanor to a felony. The act also amends subdivision 2. Now, subdivision 2 is currently an existing felony, and it is currently ranked by the commission. So that has a statutory maximum penalty of 5 years imprisonment. It currently has a statutory maximum of 5 years imprisonment because that's the default statutory maximum when no statutory maximum is otherwise specified. And that's true in the current law, but effective August 1st, it's going to be 5 years imprisonment spelled out and a $20,000 fine, which is higher than the default statutory fine. And it changes the title to felony offense to aggravated offense. So it is the same offense other than those two relaxed elements. So it's instead of just a pistol or a semi-automatic military style assault weapon, any firearm, and instead of knowing that the transferee is ineligible, knowing or should reasonably have known. Now, the thing that makes this aggravated, the thing that makes this different from the base offense is that the defendant, not the defendant, the transferee must use that weapon or possess that weapon in furtherance of a felony crime of violence within a year of the transfer. So it's really an unusual offense in the sense that you're sort of being held criminally liable for, or your criminal liability is enhanced by the behavior of somebody else after your work in the crime is done. It's almost like accomplice liability, but not exactly, because accomplice liability actually requires some knowledge about the ultimate crime of violence. But this is punishing the straw purchaser, the transfer, or for the crime that the transferee ultimately commits. And obviously, the transferee can be separately punished for the crime of violence. There's a new subdivision 4, just FYI, that supplies an affirmative defense for transferors who are acting under compulsion by the transferee. So if it's a situation where essentially they feel like that if they didn't do the transfer, they'd get hurt, significantly hurt or die, then there's an affirmative defense there. So that's the crime in a nutshell. So the commission has to consider ranking the new felony offense and has to consider whether there's any changes that need to be made in the ranking of the existing felony offense, now called aggravated offense. So the existing felony offense is ranked at a severity level of 2. It has a default statutory maximum, again, of 5 years, which is similar to the existing 5 years. It's not on the list of offenses eligible for permissive consecutive sentencing or on the severe violent offense list. The new felony offense, as I said, has a statutory maximum of 2 years. Now, we have recommendations in here. I don't want you to think of these recommendations. Don't put too much weight in these recommendations. These are just staff's recommendations, sort of like what we think it is. Trust me, our feelings are not going to be hurt it is your job, not our job, to make recommendations, just to be clear on that. But typically, we include these recommendations because they reflect probably what we assumed. And 9 times out of 10, these recommendations are the same thing that we assumed in our fiscal note when we were estimating to the legislature what the fiscal cost of this bill would be. we sort of, pretended like we were in your shoes and guessed what we thought you would do, but you don't have to take the fact that there's staff recommendations with too much weight. So the recommendation is to rank the new felony firearms transfer offense at severity level 1 because the other offense is ranked at severity level 2, and this is less serious than that. So as far as ranking the aggravated offense at severity level 2, there's no change that really, other than the increase in the fine, there's nothing about this change that increased the severity of the offense at all. In fact, it decreased the severity of the offense in a few ways because it expanded the number of firearms that can be included, and it decreased the state of mind that the defendant had to have, knowing or should have known instead of knowing that the transfer was ineligible. So it didn't make sense to staff that there'd be any increase in the ranking of the aggravated offense. So that the recommendation there is to keep that at severity level 2. And then the other offense, the new felony offense, which has a low statutory maximum, makes sense to rank that at severity level 1, which is one severity level below severity level 2, because that is less serious because it wasn't the case where the firearms used in a felony crime of violence within the next year. And then we have a few pages there, and we, there's also some technical things like we're changing the name of the offense to match the new elements and the new title, transferring firearm to an ineligible person instead of pistol. Any questions about the staff recommendation? So procedurally, I think you could do this as one motion or two motions. It's completely up to you how you wanted to do that, but you just do a motion to adopt the staff recommendations with respect to item A1. That would be one way to do it if you thought those staff recommendations made sense, and then you'd be adopting all the language in there. Or if you wanted a different ranking, you could say adopt the staff recommendations except to rank, the aggravated offense at severity level 3, or whatever you thought was appropriate there.
Commissioner Moore.
Thank you, Madam Chair. Director Wrights, I guess I did have a question regarding the staff recommendation on the aggravated offense. As I understand it, that would maintain the status quo essentially for that at a severity level 2.
Right.
Which, when I looked at that, and this is coming from an uneducated standpoint, that seemed low to me. I mean, the legislature obviously decided to do something different with this offense, with its, I guess, the increase of the statutory maximum penalty to I guess the fine was increased more than the actual incarceration period. So I don't know. It just, given some of the discussion that's happened about these types of offenses, it just struck me that the legislature was trying to send us some type of a signal here beyond, maintaining the status quo. I don't know if there's a great analog to this offense when you look at severity levels. I mean, it is unusual because it's connected to the behavior of another individual that arguably is not under control of the person who's transferring this. But 2 just seemed light to me. That was my initial impression on this. And again, I'm not being critical of staff's recommendation here. I'm just wondering, what the thought process was internally on this.
Right. And Madam Chair, if I can, I've disclosed this at other meetings, but staff's bias is a status quo bias. So we do have sort of this, and I'm not saying it's a good thing. It's just sort of like, this is the direction that the commission has given us in the past. So we will assume that will continue to be the commission's direction. And the commission has ranked this offense at severity level 2. Other than the increase in the crime, there's nothing that made it more severe. There's a couple of things that made it less severe, in terms of the expanding the firearms. And I'm not disagreeing with anything you're saying. I'm just explaining sort of why we came up with 2, because that's essentially as close to the status quo as you can get.
Commissioner Middlebrook.
Thank you, Madam Chair. I have a question also on the amendment for the $20,000 fine. Was there a fine before for subdivision 2?
It just said is guilty of a felony or something like that. So it would have been the default 5 years, $10,000.
So
it was unstated 10,000, yes.
Okay, so I guess that makes sense that they went to 20,000 when the subdivision 1 went to a felony level with a $10,000 fine. So they increased the fine for the subdivision too. I guess that, to me, makes sense why they did that.
Commissioner Mueller.
Thank you, Madam Chair. I just kind of want to echo some of the comments. And this is from someone very new on the commission and the first time really taking up any law changes for consideration. So bear with me. I think I concur that the legislative intent of this is really acknowledging the end result of this crime, which is really, I think the legislative intent was really to minimize murders, for lack of another way to say this. But this crime ends up in people dead and multiple people dead. And I think that's why it was taken up this legislative session. And the comments that I heard on the Hill were, directly related to the violence in the entire state that's happening right now. So it does also seem low to me. I'm not sure what that means or, what we can consider or how we can consider that. And again, not being critical of staff recommendations, I really appreciate that as I'm learning this process. But for me, this, in terms of firearms crimes where people end up dead, the legislature wasn't concerned about felons in possession, carrying firearms, some of those things. They were really trying to minimize deaths in the state, and that's where I would lean towards. If there's any work or consideration to have this, increase as much as possible and kind of move off of that status quo. Thank you.
Commissioner Larkin and then Commissioner Lett.
And I don't have a comment, I just have a request. Is it possible, since this is the first time we're doing this, for Nate to show the grid so people get a sense? Because I'm looking at, going up to 3, that probably doesn't make a difference. It might be helpful to see the grid.
Yeah, I just pulled it up myself, so that's a good suggestion. Commissioner Lett, do you want to say something while he's
Yes,
working on
thank
that?
you. I think, I'm not going to belabor what's already been stated, but I thought, I was kind of struck by the change in the financial obligation, because I think anybody who is practitioners know rarely, if ever, do those fines ever get imposed at a maximum level at all. I mean, if someone's incarcerated, it's a $50 fine. So it was odd to me that the increase was on the financial end, which to me was a signal that they felt like there was a consequence that should be imposed that was more serious than the other one. But it doesn't make sense. The fine is kind of hanging me up in terms of what that's supposed to signal. I mean, I just don't understand that.
Nate, can you answer that question?
I don't know.
Yeah, please.
All I know about the legislative history is that this was part of the same bill that dealt with binary triggers, and it was introduced by, at least on the House side, by the representative from Burnsville, and it had to do with the tragedy in Burnsville earlier this year involving police and first responders who were shot by somebody who had in possession a binary trigger weapon and also was ineligible to have firearms at all, and got the firearms from somebody who purchased them for him. So that's all I know about the legislative history.
Commissioner Knudsen.
Thank you, Madam Chair. And to that point, that case on the straw purchase aspect of it, as I understand it, is being prosecuted federally.
I think that's true.
Do we know what the federal crime punishment would be?
I don't.
Yeah. Presumably, it would be more severe than level 1 or 2 under our guidelines. So are we setting that, if we don't move it up, the aggravated to 3, I mean, are we basically setting up that, well, that's really, it's a federal crime and we'll just let it go?
I was just gonna say, for the benefit of the folks who are new, what the process is today is staff recommend something, and then if we have a different idea, then all that someone has to do is recommend a different option. And one of the reasons we're putting the grid in front of you, and I think this is why I went to look at it, and this is why Commissioner Larkin asked for it, is because we want to try to ensure that if we do propose a different ranking, that the row that we're proposing to put it on, doesn't exceed the maximum sentence that the crime carries. So in this case, the aggravated form is a 5-year sentence. So if anywhere on that row exceeded 5-year, was already 5 years before getting to the end of it, then we would know that we're kind of overshooting because it doesn't really fit in that row. Oftentimes, staff will also give us comparables within the different rows so that we know sort of other offenses that are in there, what their stat maxes are and that sort of thing. So it looks like we didn't get that this particular time, but that's okay.
And you can take a look at section 5A does list offenses by severity level. So you can see, for example, all the severity level 3 offenses grouped together. I'm displaying that now.
Commissioner Larkin, go ahead.
I'm glad we put the grid up so the people that are new can look. It's just not a matter of raising it from 2 to 3. That's not going to do anything. If you really want to do something, you're going to need to go from 2 to 5. And that at least would keep you within the 60-month statutory maximum. Because my thought on this is we're constantly hearing about a unanimous, if not majority, sentiment that more needs to be done about gun violence, more needs to be done about gun violence. It seems like, okay, well, here is an attempt to do something about gun violence and an attempt, to keep guns off the street. And we often hear that that's the root of the problem. There are too many guns out there. So here's a crime that gets directly at that. I don't find it difficult to believe that the legislature wanted this treated more seriously. And I agree. When I saw the fine, I said, well, just don't put these fines. No one imposes these fines. Why do we pretend that these are consequences when we don't impose them? But let's just be real about what the community expects in terms of we don't want someone buying a gun for someone else when they know that person's not allowed to have a gun, or they should reasonably know that that person's not allowed to have a gun. And I think the community would probably support a more severe sanction than just sticking with 2 and putting this in at 1. Maybe it should be 5 and 4. At least that sends a message that we're doing something to increase the presumptive sentence, even though it's only by 6 months. At least it's 6 months, which probably seems inadequate, but that's where it might neatly fall. Oh, I guess you could go 6 and 5, because 6 would keep you within 60-month max on the grid.
Well, the other offense is only a 2-year max, so you're overshooting by going above 3 on that one.
You'd actually be overshooting the top end of the range at 2. Likewise, you'd be overshooting the top end of the range at 6 for the 60-month offense.
Oh, good point.
Just a little. I'm just saying we do have an appendix where we mention that when it shoots over the top of the range.
No.
So we probably need to list those in that appendix if that were the recommendation.
Commissioner Larkin, you can finish, and then Commissioner Miller.
Yeah, just for wrapping it up then, I mean, as I look at this just from a practical perspective, if we wanted to talk about raising things in a way that would keep us mindful of the statutory max, so we're ranking things in a way that don't exceed that, we could look at 5 and 4. So at least 5 would raise the presumptive sentence on the aggravated offense 6 months from where it is now. 4, quite frankly, is the same as 1, but you do move up more quickly based on your criminal history at 4.
Do you mean for the aggravated offense, or are you talking about for both of them?
For 5 for the aggravated, 4 for the new offense.
For the base.
Okay, Commissioner Middlebrook.
Thank you, Madam Chair. I guess I don't see that we have to necessarily rank them one above the other. The subdivision 1 was a gross misdemeanor, and then they elevated that to a felony, with a 2-year statutory max, which is still really low. So it seems that we could go to severity level 2 and then higher for the aggravated without being just one above it. Because that's still a really low statutory max, and it also expands that offense to bring in more elements there, for more cases, I think.
Commissioner Moore?
Doing a little research on the fly is always dangerous, but I found the ATF website, and just to respond to Commissioner Knudsen's commentary, the amendments to the Bipartisan Safer Communities Act in June of 2022, maximum terms of imprisonment under federal law for straw purchasing to 15 years and a $250,000 fine and up to a 25-year prison sentence if the weapon's used to commit a felony, an act of terrorism, or a drug trafficking crime. Now, we that have been prosecutors know fully well that the federal laws are typically significantly different than state laws regarding penalties, and the sentencing guidelines are a lot different, but it does give you a little sense of where the federal government sees this. And, you know, I just to follow up on the discussion here, I agree that we should seriously consider the trying to do more, at least on the aggravated element. I think Commissioner Middlebrook makes a reasonable point on the base crime. If we're talking about something that was raised from a gross misdemeanor to a felony, that doesn't seem like that's something that maybe should be beyond a 2. But I think a 5 on the aggravated firearms transfer offense, to me, seems to fit a little bit more about the seriousness of this. And again, it's hard because there's not a great analog in terms of crimes to look at within that range, but that would be my thought.
Commissioner Larkin?
And I made a mistake, and I was not paying attention to the last box for the new offense. So I agree. I think that the important thing to try to do would to be raise the aggravated, even if the new offense is at a 1, because it looks like that's the only way to stay within 24 months, right?
You can stay within 24 within the box on a 2. The top end of the box is 25. So you can be within the box at 24 months.
Oh, okay, very good. I don't know why I'm having such
Sorry.
difficulty with this concept. You're right.
Oh, Madam Chair.
Commissioner Knudsen?
So let me start this off. I would move that the, I think subdivision 1 be ranked at a level 2. So we're moving it up 1 severity level, and we're within the maximum penalty that they changed under the law.
Is that where you're leaving it? Just going with that one right now?
I'm just, yeah, let's just,
Okay.
let's just move one thing at a time.
Okay. All right, do we have a second to that? Commissioner Reeves seconds. Any discussion on that motion? I don't disagree with that. I think that's fine. If there's no discussion, I think we can go to a vote on that one.
To the,
Madam Chair?
Oh, sorry, Commissioner Mueller.
Yeah, thank you very much. Not to belabor this any longer, but I appreciate the discussion amongst all of you experts and helping me understand kind of how to navigate the guidelines. I feel the need to say from my role and my lens that, you know, persons crimes, especially, you know, the crimes of violence that we're seeing and the elevated amount of violence we're seeing in the state and the region, these crimes, when I look at the list of crimes we're considering today, you know, this, I would even say the targeted misdemeanor of harassing telephone calls as that relates to crimes of violence specifically against women, but this crime is very significant. So I appreciate the consideration and the discussion, and I would just reiterate the legislative intent is to move this to as high as we can, absent any legitimate or significant gun control. This is one way that we can, I think, help keep our citizens safe. So thank you.
All right. Any other discussion before we vote on that motion? Hearing none, we can take the roll on that.
to the Knudsen motion to rank the offense described in 624.7141 subdivision 1 effective August 1st, 2024 at severity level 2. Larkin?
Yes.
Larkin, yes. Crutchfield? Crutchfield absent. Phrase?
Yes.
Phrase, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Moran? Moran, yes. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena? Saxena absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
With that, the motion is approved unanimously. All right, so now we have to take on subdivision 2, the aggravated form of this.
Could we have the grid back up for this?
Can we put the grid up? Yeah, when you have a chance. Thank you.
I think somebody asked if there was another crime where somebody was held liable for something that occurred sometime after their crime was complete, basically, and I'm struggling with that. I can't think of another crime that's like that. Maybe somebody else can think of a crime like that, but it is definitely unusual to sort of be done with the crime and, you could be on vacation in Hawaii and somebody else commits or moved out of the state and then somebody else commits another crime and then that makes your liability increase.
Commissioner Moore.
Madam Chair, Director Wright said the one thing I was thinking about is, some felony level of aiding an offender after the fact. I mean, there's different variations of that. I haven't researched that in terms of where that 495, I think 609, 495, that's the closest thing that I could think of.
Commissioner Larkin.
Just because I seem to be having difficulty with the chart today. So I'm correct, as to subdivision 2, the aggravated offense, the highest it could be is 6, because 60 falls within the end of the top range.
The commission is free to put it anywhere on the grid that it wants, but it certainly is a consideration the term I use is that it fits on the grid.
Well, and I respect that, and I've been saying the wrong thing over and over, so I just want to say the right thing once. So just for purposes of discussion, we could all be informed that consistent with our practice, the highest we would place this would be level 6 because the statutory max for the crime fits within the maximum sentencing range at the right end of the grid. Then the other thing, and I don't know how this impacts this, but one thing that's curious to me is I thought the legislature had changed aiding and abetting and made it more difficult to obtain a conviction for aiding and abetting. And you need to, or for felony murder, is that what the recent change was? For felony murders. So it seems a little inconsistent on one hand to say, well, we're not going to hold you accountable for felony murder unless you knew this was likely to happen, or whatever. As I understand the change, I can't articulate it. It was to make it more difficult to convict people of felony murder when the outcome wasn't foreseeable. So that stands in stark contrast to this law, which says you might be responsible for anything anybody does with a gun, if I'm understanding it correctly. So just throw that out for thinking about what they've done and how they're doing it.
And I would just add, if the motion is to rank it at severity level 6, then I would infer in that a motion also to add the offense to Appendix 3, which is the list of offenses where the presumptive sentence durations exceed the statutory maximum sentence, because that's true in the upper range. And a lot of these are like that. You'll see that it's listed in the upper range where it exceeds the statutory max. But
I thought we agreed that 6 doesn't exceed the statutory max.
only at the upper range. So you could certainly sentence to the statutory maximum at criminal history score of 6. But there are numbers on the grid that you could not use because the grid
Understood.
has the number 68 there, and you couldn't use the number 68.
But you would, I'm sorry, Madam Chair,
Go ahead.
but you would
Commissioner
still be within the grid if it was sentenced at 60 months, because it would be within the grid and it wouldn't be a departure because it's there. It's just that you couldn't go to the 68 because that exceeds the stat max.
Yep.
Right.
Yeah, and so what we're saying is we generally try to avoid putting it on a row where we're gonna go beyond the stat max. But as you can see from the table that Nate just pulled up, there are instances where we have done that. So it's not a hard, fast rule, it's just,
So didn't we just do that on the prior one though? Because it's 25 months at the top, so does that,
Yes.
that one would have to be adjusted in that appendix as well then?
Yes, actually,
Okay.
actually, I'm going to throw that on the next motion.
Okay.
Thank you for pointing that out, because we will want to change appendix 3 regardless.
but it is but the stat max is also our guidepost that the legislature has given us for relative to other offenses. This is about the appropriate punishment, right? And so we tend to try to put offenses on the rows that have similar stat maxes. So, what I don't know is if we go to 6, what do the stat maxes look like? Assault in the second degree, isn't that like 10, 15 years or something? I don't know. So a lot of those are much higher stat maxes than the 5 years that we'd be giving it. We don't often have offenses except if they're at the very bottom where you get to the stat max by getting out to criminal history score of 6. Just putting all the information out there, because we have some people who haven't done this. Commissioner Middlebrook had her hand up, and then Commissioner Larkin.
Thank you, Madam Chair. I guess my concern, understanding, the concern about this offense, but we've got to also consider the culpability. And if you look at some of the other offenses that are in, particularly this level 6, that defendant's culpability is much higher than a defendant in this situation. Obviously, if it's a really egregious case, there's departures available. But it just seems like the legislature didn't increase the statutory max, and they could have, to make it a higher statutory max or a mandatory sentence, and they didn't. They left it at a 5-year stat max, so it seems to jump that high up isn't following what the legislature intended with changing this, or increasing just the fine.
So would you have it? I'm just wondering if.
I just think 6 is too high, given the other offenses that are in that level.
Commissioner Larkin, then we'll go to Commissioner Mueller and Commissioner Fraze.
I appreciate that when you look at the offenses in 6, like assault, second, first degree burglary, there is more culpability for the defendant. But I can't ignore kind of the constant message that we need to get guns off the street, we need to control gun violence. And this is a crime, though, even though the person who's supplying the gun, it might not seem like that big of a crime. I mean, it leads to tragic results, and it's putting another gun in the hand of someone who's prohibited by law from having a gun. And even at a 6, you would need to have 4 criminal history points before you faced a presumptive prison sentence. I just think in the big picture of societal concerns, which I think influences legislative intent and a constant statement of a need for gun control, 6 makes some sense. At the very least, it should be 5. Anything 2, 3, or 4 that starts out at 12 months, same as the non-aggravated subdivision 1 offense, doesn't make any sense.
Commissioner Mueller.
Thank you. I definitely appreciate the conversation on this. And to the commissioner who brought up the felony murder, I sat on that commission, and absolutely, through the lens of law enforcement, we're absolutely in favor of holding those most culpable accountable. And in that case, there was story after story of individuals that were just simply driving a car involved setting up a meeting, doing sort of innocuous things that ended up, they didn't have the knowledge or, pardon me, with not having the specific language, but they didn't have knowledge that their sort of other individual was going to commit a violent crime. What we see now with straw purchasing is the individual absolutely knows or should reasonably know that buying a firearm for a felon or someone who is ineligible to possess a firearm, there's nothing innocuous about that. That's not just driving a car and then, oh my gosh, my boyfriend did a drug deal. I can't believe that happened. I had no idea. I thought he was meeting a friend. And there were some stories about that. We were going to, he was going to go steal something. He ended up robbing it and committing a murder at a pawn shop. And I'm talking about felony murder, but with the straw purchasing, I think it's such an overt act that individuals should reasonably know that this could end in violence, and probably will end in violence. So I'm absolutely in favor of placing this at a 6. That's where I'm at with this, as high as we can go. Because I've seen and we have all seen the tragic results from this, and I haven't heard any stories of in my career of straw purchasing that where I just bought my significant other, a friend of mine was looking to go hunting, so I bought him an assault rifle or a pistol, and he didn't go hunting or she didn't go hunting. They committed murder, and so that's kind of where I feel I appreciate the conversation on culpability, because that's what we want too, and that's I think what society and our citizens want for sure is that kind of even playing field. But I'm definitely in favor of a 6 on this. So thank you.
All right, Commissioner Fraze. Commissioner Fraze, are you there?
Okay, sorry.
Yeah.
I'm new to WebEx. And I'm a newbie here. This is my first round in ranking offenses, and I guess I knew it would be challenging. The concern I have in this process is that we it's kind of a bit of the crime of the week thing. So we're looking at one crime. The risk is we're leapfrogging a bunch of other crimes that are also very serious. So then we come back and say, well, then maybe they should be ranked up too. So it's just really difficult to do it one crime at a time. This particular crime, the aggravated version, now my understanding, again, I don't have the statute in front of me because I don't have a printout of chapter 624, but my understanding from Nate's summary is that where even though this is an aggravated offense, it's aggravated because of a prior conviction for this crime. The crime itself, as I understand it, now does not require the defendant knew the transferee was ineligible, but only should have known. And the transferee has to commit a crime of violence, not necessarily murder, but the transferor, the defendant, doesn't, there's no required proof of accomplice liability or even knowledge that anything, how the gun is going to be used. So it is in terms of culpability, yes, if the gun ends up being used to kill somebody, that's a horrible result. And we always kind of want to look back and say, well, how could we have headed it off? But the culpability, the required culpability for this crime, as I understand it, isn't very high. I was on the second iteration of the felony murder task force, and so in both iterations, the goal was to make sure that even when someone is charged as an accomplice, we have to prove a high degree of mens rea. Not just that they should have known that the primary party was going to do this, but that they knew them were going to do it, wanted them to do it, had a real intent. Here again, we don't have any proof of accomplice liability required. The last thing I'll say about the task force experience, and something that I think brought us together in the second round, was that the prosecutor, we looked at the actual cases, and in many of these case files, it could be proved that the secondary party actually was a knowing intentional accomplice. And so the prosecutors on the task force say, okay, we can live with this stricter mens rea rule because when we need to, we can prove culpability on the secondary party. And I think that is what should be done rather than a rule that imputes a high degree of culpability with no proof.
Nate, and then Commissioner Larkin.
So I just want to clear up a couple of things about the mechanics of how this law works. One is the aggravating element to the aggravated offense is not that the defendant had a prior or the defendant had any kind of record at all. Presumably, the defendant didn't have a serious record because he or she was able to purchase the firearm. The aggravating element is the fact that the transferee, not the defendant, used or possessed the firearm in connection with the commission of a crime of violence, which is the second thing I wanted to point out. So the crime of violence list that's being used for this is the same crime of violence list that disqualifies somebody in the first place. So it causes the lifetime ban from ever possessing a firearm. And while there's no question that the vast majority of offenses on that list, everyone would agree is in fact a crime of violence. There are some offenses, and I think the chief example is a felony violation of Chapter 152, which is the controlled substance crime law. That's also considered a crime of violence for that list, and that's the same crime of violence list. That I think goes back to a comment Chief Mueller had said about, using, being, the knowledge was just that it was a drug sale. So if the defendant were to possess this straw purchased firearm within a year of the transfer in connection with a drug sale, for example, or a drug possession for that matter, that would suffice to meet the aggravating element for this crime.
Commissioner Larkin.
First, I want to thank Commissioner Mueller for sharing, and Commissioner Frazier as well, some explanation of what the thinking was behind felony murder, because that does put it in good context for me. And you made a good point. In those cases, we have a lot of people that are really just sort of present and not knowing that something could go terribly wrong. But if you are buying a gun and giving it to someone who you know is prohibited from having it because they have a criminal history, or you should reasonably know that, that does seem like far more culpability. So I appreciate that comment. The other thing I just want to clarify is, as I understand it, under this new law, you don't have to prove that the person who purchased the gun knew the recipient was going to commit a crime. The mens rea requirement is simply that the person who purchased the gun knew that the recipient was prohibited from possessing it or reasonably should have known. So that's all that needs to be proved there. I guess, pardon, precisely. So I guess what I would say this, I think there's value in considering a 6. I would support a 6. I'd point out that as I understand it, if we vote on this today, it's contingent on the results of our consideration of comments at a public hearing. And then we would reconsider whether to keep it at a 6 or go lower. And then regardless of what we do, it goes to the legislature as a recommendation, which the legislature can reject if it decides to reject it. So, with that, I would move that we rank the aggravated offense, I guess that's subdivision 2, at a level 6, pending a public hearing on that ranking and then subsequent action based on the comments, and that we also modify whatever appendix we need to modify if that's necessary.
So Commissioner Larkin make that motion. Commissioner Reeves second. Any discussion on the motion? Do you have what you need for the motion?
Yeah, I just want to clarify one point about the process. So because this change relates to a crime that was created or amended by the legislature in the preceding session, the commission actually has more power, if you will, than if it were just a commission initiative. So this actually will take effect August 1st, and it will be sort of an after the fact notice to the legislature that here's what we did last year, more than here's something we'd like to do, and then they have now obviously they could undo anything the commission does, but this will in fact take effect on August 1st.
Commissioner Larkin.
And again, this is just for the new members too. And I appreciate that clarification. I was thinking of things we've done in the fall. But just so everybody is aware, the way, as I understand it, our authority works is we make the change and then we notify the legislature. And if they do nothing to modify the change we've made, it remains the law. So
Not
whether,
at this time,
pardon?
not right, not this change. No, this goes into effect.
Oh, I understand it goes into effect, but what I'm saying is, if this is something we did on our own initiative, we had our fall hearings, and then we voted to change the ranking on something, we would send the legislature notice that we did that. And if the legislature takes no action, then our action stands. So I guess what I'm just trying to communicate, because it was a surprise to me, I just assumed when I joined the commission, we make recommendations and then the legislature says yay or nay. But as I understand it, regardless of whether it's this process we're having now, where we're having to rank something over the summer, or we do something on our own initiative, we make the decision, the legislature is made aware of it, and if the legislature does not act, our decision stands. So it's not really a case where we're ever seeking permission from the legislature, right?
It's not quite how it works for all of the for all of the legislative changes that occur during the session that change or amend crimes and require us to do a ranking decision. We do that now, and it goes into effect. The legislature does not have a role in stopping or doing anything to change that path. We do that right now. The only things that go to the legislature are things that we purely initiate on our own without this is the only exception. Everything else we do pretty much goes to the legislature for that veto, potential veto.
Understood.
This is the one thing that we do that goes into effect immediately, but we just have to have that public hearing first. So. Okay, we're in discussion on this motion. I find this one really difficult because I do think that responding to gun violence is extremely important. And it is one of the areas that I personally feel like our legislature has not acted enough in this area, and so it's good to see things in front of us. At the same time, the way that they have acted does not put a significant penalty on this offense. And being a member of this commission, I have to take that direction as well. And to me, putting it at a 6 is going beyond the signal that they've sent to us. And I think it would be that we would be better served, or that it would comport with legislative intent if we ranked it somewhere lower than that. That's not the motion that's before us right now. So I'm struggling with where that might be, that would be lower. It kind of doesn't matter if this motion ends up passing. So I do intend to vote no against this motion, because I just think 6 is too high given a statutory maximum of 5. And looking at the other offenses that are on that same ranking with much higher penalties. Commissioner Knudsen.
I feel the same way. I mean, we're charged with trying to apply our rankings rationally, proportionally, and with an understanding of what did the legislature intend. I mean, look at the staff recommendations, which with their experience and the standards or the elements which they consider when making these recommendations, they recommended a 1 and a 2. And we're jumping up really high. And then to Professor Fraser's point, we're leapfrogging a bunch of offenses that are more serious, I think, than this newly created crime. I would support And then we're also going beyond the statutory max at the top end. So, and I guess bottom line, we spent a lot of time talking about this. I don't think it makes a lot of difference. We're looking at a first-time probationary sentence. And then when you finally get to the commitment to the commissioner, you're looking at a difference of 6 months on a 33 versus a 39. But I'm trying to look at it not just simply at this crime. I mean, I just remember serving in the legislature. Somebody dies and that legislator brings forth, and all of a sudden we are upending the proportionality and proposals to make the very disproportional decisions in ranking of crimes. And I just don't think the legislature inkled that with their setting a maximum on this, the aggravated offense. So I guess that's my comments.
Okay, Commissioner Mueller and then Commissioner Ladd.
Thank you. This is great conversation. I really appreciate everyone's insight. And Your Honor, just a couple of points that you just made. I definitely see what you're saying in terms of, and Commissioner Fraze mentioned this about leapfrogging. And when I just look at the left side of some of the crimes that we're leapfrogging, non-residential burglary, so a burglary of a business, unoccupied, residential, simple robbery. Like I can say that a straw purchaser of a firearm has a higher degree of death than any of these crimes, that I'm looking at. And so I think that's where that's where I stand on this. And yeah, if the legislator would have acted, and put a higher level up there, that might have given us more insight into legislative intent. But I also suggest that you're correct. There is a sort of knee-jerk reaction to a death in the community as a legislator, responds to his or her constituents and tries to make some changes, in public policy or whatever that might be. But again, that we're not talking about changing filtering systems and pools that could result in a death, and we're not talking about some of these changes, rules for scuba diver certification for individuals at work that could result in death. We're saying that when someone buys a firearm for an ineligible person, I'm here to tell you that there's a high degree that results in death, and that's why I advocate for the higher part. Thank you.
Commissioner Ladd.
Thank you. I think I'm just gonna take this opportunity to express my frustration with this little grid thing. I think that severity level 4 offense category has always bothered me, captioned as non-residential burglary, because that's where felony domestic assault lives, felony strangulation, felony third-degree assault on a minor child. So to say, because we talk about that sometimes being the pressure point, and those are like property crimes. There's a lot of person crimes in number 4. So I just want to say that list there on the left side of that axis is not super helpful, I think, for a lot of folks in terms of what's encumbered in there. If you look, and it's unfortunate it wasn't included, but we have access to it. If you look at the various offenses that are in severity level 6, theft over $35,000, price fixing or collusive bidding, counterfeit, medical assistance fraud, just as there are some person crimes in there, catalytic converter crime, over 70 converters. So I get that there's this point, if we change one and we leapfrog something that it affects other things, that's part of the comprehensive process as well. But as to this point, we can't change it all today in one thing, but I think we have to look at this. And again, I struggle with the idea that this increased fine penalty was a signal of an increased punishment of sorts, even though practitioners know the fines are really sort of not imposed. And so why 5 years as opposed to 7 or 10 as a stat max? I don't know. But that's where I struggle. And I just think that if you look at the list, and Nate's got it up there now, even ineligible persons to have firearms, felons in possession of firearms or ammunition, they're in this category. there's a wide range of stuff. And so I don't see this as leapfrogging anything per se, because there's a lot of stuff in 4, a lot of stuff in 5 that are both person and property. And so I don't think that you can just necessarily look at it such a narrow view that way. Just my 2 cents.
Any other discussion on the motion? All right, well, I think it's time to vote then.
All right, to the Larkin motion to rank the crime that will be codified at 624.7142 subdivision 2 effective August 1st, with directions to staff to draft all appropriate changes to appendix 3, to rank that offense at severity level 6. Larkin.
Yes.
Larkin, yes. Crutchfield. Crutchfield absent. Phrase.
No.
Phrase, no. Knutson.
No.
Knutson, no. Ladd.
Yes.
Ladd, yes. Middlebrook.
No.
Middlebrook, no. Moore.
No.
Moore, no. Morin.
No.
Morin, no. Mueller.
Yes.
Mueller, yes. Reeves.
Yes.
Reeves, yes. Saxena. Saxena absent. Chair Mitchell.
No.
Chair Mitchell, no. Madam Chair, there are 4 votes in favor, 6 votes opposed.
So with that, the motion fails.
Madam Chair,
Commissioner Knutson,
I would move that we rank it at severity level 5.
do we have a second?
Second.
Commissioner Moore seconds. Any discussion on that motion? All right, I think we don't have any more discussion, so we can vote.
To the Knutson motion to rank the crime that will be described at Minnesota Statute 624.7142 subdivision 2 effective August 1st at severity level 6 with directions to staff to draft all appropriate changes to appendix 3.
Said 5.
I'm sorry, I just cut and
Severity
paste.
level
Thank you. Severity level 5. Thank you. To rank that offense at severity level 5. Larkin.
Yes.
Larkin, yes. Crutchfield. Crutchfield absent. Phrase.
No.
Phrase, no. Knutson.
Yes.
Knutson, yes. Ladd.
Yes.
Ladd, yes. Middlebrook.
No.
Middlebrook, no. Moore.
Yes.
Moore, yes. Morin.
No.
Morin, no. Mueller.
Yes.
Mueller, yes. Reeves.
Yes.
Reeves, yes. Saxena. Saxena absent. Chair Mitchell.
No.
Chair Mitchell, no. Madam Chair, there are 6 votes in favor, 4 votes opposed.
With that, the motion's approved.
All right. The next item is item A2. And that is colloquially known as doxing. It's threatening or basically releasing personal information or publishing personal information on a judicial official, which chiefly consists of judges. And the personal information includes home addresses and children's names and schools. There's an exception if that information is publicly available. I want to emphasize that the base offense is a misdemeanor and it includes an intent element. There has to be the intent to threaten, intimidate, harass, or physically injure. And that's the misdemeanor. The felony is if the offense causes bodily harm. So this would be publishing personal information of a judicial official with the intent to threaten her, intimidate, harass, or physically injure, and bodily harm results from that. So there's no statutory maximum specified, so that 5-year default applies. There's a similar offense of judicial harassment that exists now, which prohibits harassment with intent to influence or tamper with a juror or judicial proceeding, or with the intent to retaliate against a judicial officer, prosecutor, defense attorney, et cetera, because of that person's performance of duty in connection with a judicial proceeding. That also has a 5-year statutory maximum. And that offense is ranked at severity level 4. And all harassment is eligible for permissive consecutive sentencing, and that's that section 6 that we talked about. So the staff recommendation, again, with our status quo bias, we're looking at the most similar offense and ranking it at that same severity level, which is severity level 4. That's shown here on the screen. And then we also recommend adding it to the list of offenses eligible for permissive consecutive sentences. We did include the entire list here in this document just for your reference so you can see what the other offenses are. But essentially the history and I think continued intent of the commission is that these offenses are crimes against persons. And the guidelines used to just say crimes against persons, and the courts were like, well, that's a little fuzzy. So the commission listed all the crimes against persons. So that's severity level 6, or that's section 6 of the guidelines. And this seems to fit based on the elements of, first of all, there has to be that intent to threaten, intimidate, harass, or physically injure, and then there has to be bodily harm resulting. So it sounded to us like it's a crime against a person. So that's why staff's recommending listing it at section 6 of the guidelines. Any questions?
Commissioner Knudsen?
I think level 10 is reasonable. Kidding.
Commissioner Larkin?
So I'm just wondering how this works in practice, because if there is bodily harm, that offense is going to be charged as a separate offense. So is this anticipated to be a situation where one person releases the information and then somebody else commits bodily harm? How do you ever tie that together? I suppose there's always a chance, but.
Yeah, I think the way doxing often works is that somebody, like there's some internet troll, or for lack of a better term, who's releasing this information and saying nasty things about getting people fired up. And then somebody gets fired up by that and goes and commits does something, hurts the kid or whatever, causes bodily harm. So this way, both people can be punished. The person who did the doxing and the person, yes, I believe the person who commits the ultimate bodily harm would be separately punished.
And let the record know, like words like doxing, internet I don't know, any of these things.
Yes, sorry.
But now you've explained it. So the crime we're punishing, it's not based beyond bodily harm, whether it was a black eye or, God forbid, something much worse. The liability of the person who released this information is the same. So long as there was some harm. It doesn't matter that you got someone riled up and now someone's dead, as opposed to you got someone riled up and somebody pushed somebody over. We're just punishing kind of the notion of motivating people to do something that
Right.
causes harm.
Right, and it kind of reminds me of the next offense, which is swatting, and that's the crime where you call in a fake emergency into somebody else's house, so they have a bunch of police respond, and that crime is sort of developed over several legislative sessions where they've added different severities depending on the level of harm. But it wasn't like that when they first introduced it, so it's possible that the legislature would come back later and fill in some of these blanks for doxing. Doxing and swatting, I feel so bad.
All right, any feelings on this one?
I would move to adopt the staff recommendation.
Okay, we have a motion, do we have a second?
Second.
So Commissioner Ladd makes the motion, Commissioner Larkin seconds. Any discussion on the motion? Hearing none, when you're ready, Nate will take the roll.
All right, and I think this is A2. So to the LAD motion to adopt the staff recommendations in section A2 of the 2024 modifications document. Larkin?
Yes.
Larkin, yes. Crutchfield? Crutchfield, absent. Phrase?
Yes.
Phrase, yes. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Moran?
Yes.
Warren, yes. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena? Saxena, absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
With that, the motion is approved unanimously. We'll move on to the next one when you're ready.
Thanks. All right. So as I said, the next one is the swatting offense where somebody reports an emergency, but it's a fictitious report of an emergency. And they report the emergency at a place where they intend for an emergency response to occur. Sort of as a prank, but it can definitely, obviously you've got police involved and they could have weapons and things can go bad. So it's a gross misdemeanor. The base offense is a gross misdemeanor, but if substantial bodily harm, great bodily harm, or death results, the case is a felony under subdivision 2A. So that's done, and the commission's already looked at ranking those felonies. This is a new crime that is really independent of the degree of harm. It's specifically if the place where the swatting is called is to the home of an elected official, judge, prosecutor, correctional facility employee, or peace officer. So if that's the destination where the swatting is called to, then it's a felony, regardless if there's no bodily harm at all. So basically the gross misdemeanor level offense is elevated to a felony if there is, if the site of the call is the home of one of these officials. Now, I will say that this is the one and only felony offense in the state of Minnesota where the maximum penalty is 1 year of imprisonment. As you may recall, and I don't even want to comment on this, but it's a new, this is a new thing where a felony carries a maximum penalty of 1 year. The court administrator has directed judges not to impose felony sentences of 1 year just for confusion. And you may recall that the commission, for those who were on the commission last year, you may recall that that's why we said that a sentence of 1 year and a day is never a departure, aggravated durational departure, because we want to give judges the freedom to sentence to 1 year and a day in keeping with the district or the judicial branch administrator's guidance. But you can't do that here because the maximum penalty is 1 year in prison. So that's interesting. This shows the rankings for swatting with the great bodily harm and death at severity level 8, and with substantial bodily harm is severity level 3. And staff recommends, due to the minimum felony statutory maximum, literally if it were a day lower, it would be a gross misdemeanor. We recommend ranking the new felony swatting offense at severity level 1, which is 2 severity levels lower than the existing felony swatting offense, resulting in substantial bodily harm. And even at severity level 1, we're going to have to list this in Appendix 3 because it will exceed the statutory maximum in criminal history score of 3.
Wow.
So there you go. That's and we talked about whether it should be included in Section 6. We're recommending against that because hopefully there is no bodily harm that results. Hopefully it is just a prank, but it is a prank at these officials' houses. So, but hopefully not bodily harm involved. So you may have a different perspective on this, but staff isn't, at least at the outset, recommending that this be listed in Section 6. We don't really see it as a crime against a person, but obviously the commission may have a different view. So we're just recommending ranking the offense at severity level 1 and making a few other minimal style changes in the neighborhood.
And I think Commissioner Larkin had a question.
He scrolled and answered my question.
Oh, okay.
Thank you.
All right. Commissioner Moore.
Thank you, Madam Chair. Director Wrights, in your presentation, you discussed the question of whether this would be an offense eligible for permissive consecutive, and the question of whether this was viewed as a person offense. Any thoughts on that issue? I mean, it does seem like it's directed at an individual.
Yeah, well, and that's one of the reasons why we included the list of person offenses in your materials. So you could scroll back up to pages, the preceding pages that lists all the person offenses. I think it's a close question. I really do. I think a reasonable commission could include it on the list. A reasonable commission could exclude it from the list. I don't think there's a strong, guideline status quo reason for either choice. So I think it's really up to you whether you view it as a person offense. I think it was an easier question on the last one because there needed to be person-to-person contact. I mean, this could just be a knock on the door and I'm sorry, Judge, must have been a mistake.
Thoughts from anyone?
And I'm saying that without any law enforcement experience. So, Chief Mueller, you that may not be at all what the interaction would be like in a swatting situation. So maybe Chief Mueller has some insight on whether this is a crime against a person.
I would be hard pressed to say it's maybe a crime against person. I agree it's it's targeted at an individual. But this is more of twofold. One, resources and response. The response is typically not a knock on the door. The response would be a kind of a large scale public safety response. And then, but secondly, yeah, the major concern is that, as we're trying to make contact, bad things could happen just in that scenario. But yeah, I think it's more of a just again, I don't want to say it's not a, well, maybe it is. I don't know that it's a person's crime. More of a resource and response and ultimately concern for what could happen at the end, if I've sort of characterized that correctly for you all.
Commissioner Larkin?
The concern I have when I see this is, well, if we're down officers, as we are constantly being told by the media, and we're sending, a huge response to a fake call, well, what's happening elsewhere when those officers are wasting time at a fake call? So, I mean, that's sort of another part of this. I don't know that makes it a person crime. It's more a crime against the community and one that impacts community safety.
Well, I can't make a motion, but if I were to, I probably would go with the recommendation from staff. So I don't know if anyone has a motion they want to make.
I will make the motion to adopt the recommendation of staff. I think it is the only thing we can do here.
Okay, Commissioner Larkin makes that motion. Commissioner Knudsen seconds. Any discussion on that motion? Hearing none. Well, thank you. We'll go ahead and vote on that.
To the Larkin motion to adopt staff recommendations as stated in section A3 of the 2024 modifications paper. Larkin?
Yes.
Larkin, yes. Crutchfield? Crutchfield absent. Phrase?
Yes.
Phrase, yes. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morin?
Yes.
Morin, yes. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena? Saxena absent. Chair Mitchell?
Yes,
Chair Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
with that, motion is approved unanimously. So we have one more offense to rank here, so we'll do that individually again, and then the next section is all technical. So when we get there, we'll just have Director Wrights run through all the technical changes, and we'll try to do those in one motion.
Okay, so this is sale of human remains. It's a new felony. Apparently there are websites where you can buy human remains. There are certainly exceptions for science and so forth. It's a default 5-year statutory maximum again. This offense, by the way, is already in effect. It took effect the day after enactment. So if somebody were to commit this offense now, it would be unranked. The recommendation is, I don't know, I mean, I almost wanted to say, leave this unranked because it probably is the kind of thing where it's probably not going to happen that much, and it's, you know, there's a good basis for sort of waiting and seeing what these offenses really turn out to be. By the way, cremains are also human remains for the statute, just FYI. So there is an offense of illegally damaging or illegally molesting human remains or burial grounds. That's ranked at severity level 3. Also has a 5-year statutory maximum. So we thought maybe you could rank it at severity level 3. So that's the staff recommendation.
Any discussion on this one or questions? Commissioner Webb?
And I apologize for my ignorance if I should know this, so I'll just say that first. So is there a policy per se or a guiding principle with the sentencing guidelines about having unranked offenses? Like we have a wish not to have things unranked, or I guess because I'm with you on this in terms of the ranking of it and whether or not it's even going to be a thing to kind of see what happens. So is there some kind of policy per se within our guidelines?
Yes, there is that comment that describes sort of the 3 attributes of unranked offenses, and we basically recited that. I mean, I think, you know, in general, unranked offenses are antithetical, maybe antithetical is too strong of a word, to sentencing guidelines because there are no guidelines for those. It's basically, as you know, up to the judge to rank an offense on an individual case, which is the opposite of sentencing guidelines. So it's comment 2A04, and it
Got it right there.
yeah, it says unranked offenses typically are rarely prosecuted or cover a wide range of underlying conduct or are new, and the severity of a typical offense cannot yet be determined. You know, I think it was Commissioner Saxena, who's not here today, but who said that was kind of one of his areas of concern about the sentencing guidelines, are the fact that there are these number of unranked offenses, and you know, wanted to see that changed. So
I'm sorry, I probably asked that question poorly. I read this, but I'm just saying generally, is there sort of a push to have everything ranked, even if it's rarely, I mean, I understand this, but I'm just saying, is there just kind of this prevailing thought amongst the commission as a whole that we want to have things ranked, regardless of the frequency of them, I guess? So to leave it unranked, I guess, would be counterintuitive to maybe what sort of our charge is. I guess that's what I'm looking at as a question.
Commissioner Larkin?
I don't want to speak for Commissioner Knudsen, but I remember when I was a district court judge, or Justice Moore, and then I had an offense that was unranked. I think the judges would appreciate the rankings because it just, you know, it's sort of what we're going through here for an unranked offense. Now a district court judge has to go through all of that on their own and try to come up with the right number. So I think it makes practice easier for the judges and, quite frankly, the parties, because if they're trying to negotiate cases and they don't know what the ranking is going to be, I think that would compromise their ability to, one, advise a client regarding possible outcomes at trial and to negotiate a case. I think I would favor ranking where we can.
Commissioner Reeves?
Thank you, Madam Chair. Considering that the legislature thought to make this a new felony, I'm not sure if there was an issue. This is just a very interesting charge to me, but I would support, I just cannot imagine, but I would support taking the staff recommendation on this because the legislature thought to make it a felony, a new felony at that. And so I would like to see also in my day-to-day that offenses are ranked for purposes of precinct investigation, et cetera. So I would support the recommendation. Thank you.
Is that like you're making a motion?
Motion to
support
do
it?
this recommendation, yes.
Okay, so Commissioner Reeves has made a motion. Do we have a second?
Second.
Commissioner Larkin seconds. Any discussion on that motion?
Well, I'd like to just follow up on that discussion. Absolutely. I've had a couple. And we just sit back in chambers with both counsel and say, I don't know, what do you think? I don't know. And we don't have the background, the knowledge of the guideline comments to really make a decision that anyone's really comfortable with. And it affects so many things, the negotiations, the probation. So I like to see things ranked.
Yeah, and just to go on that, I think that where I have seen it more frequently is where the law was written in a way to provide more room for how severe the crime could be or what the culpability of the individual could be, where there's some wiggle room there, and it really feels like something that could land in different places on the grid. This feels a little more concrete to me, and so I would feel comfortable ranking this. Commissioner Reed?
If I could say another point,
Go
to your
ahead,
point, I think that also helps in some of the disparities that we see in sentencing. So I like to think that there is a severity level to it, because yes, if you have this wide range, what oftentimes looks like in the system that we currently sit in, those that are more of the marginalized communities come down to one end and kind of just on the other end. So much further. Thank you.
Commissioner Middlebrook?
Thank you, Madam Chair. I guess I just have a question on this, the ranking at disparity level 3, in part because I don't know, maybe Director Ken, do you know, is there an intentional element to this, or is it just if they sell a base and it happens to have the ashes in it, that's going to fall into this category? Or I don't know what the actual crime is.
It's pretty straightforward. The person is prohibited from selling human remains or offering human remains for sale, with a lot of exceptions. And human remains is defined to include cremains.
So it's, so in other words, we can continue to do this for research purposes, like a university can still get remains for medical research, and they can purchase those. Those sorts of things are allowed.
And also if you're, if you buy a lot with a cemetery, an old cemetery on it, that's not a violation. That's another exception. But other than those exceptions, there's no particular mens rea that's required or knowledge that's required. It's just selling human remains or offering human remains for sale.
Commissioner Middleton?
So, thank you, Madam Chair. So I guess my question then is this as serious as damaging or the illegally molesting human remains of burial grounds? I guess if there isn't any, I don't know, that's, I guess, my question. Is it really that same severity level?
Where's that one?
That is the severity level 3.
Oh, okay.
It's sort of our model offense.
Yeah.
Oh, gotcha. I'm sorry. I was a little slow there though.
It must be done intentionally, willfully, or knowingly.
Okay.
So that definitely has some mens rea attached to it.
Okay.
Any other discussion? Hearing none, we do have a motion on the table, so we can go ahead and vote on that.
All right, to the Reeves motion to adopt staff recommendations as stated in section A4 of the 2024 modifications document. Larkin?
Yes.
Larkin, yes. Crutchfield? Crutchfield, absent. Phrase?
Yes.
Phrase, yes. Knudsen?
Yes.
Knudsen, yes. Ladd?
No.
Ladd, no. Middlebrook?
No.
Middlebrook, no. Moore?
Yes.
Moore, yes. Moran?
Yes.
Moran, yes. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena? Saxena, absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
No, there's
Or two.
I'm sorry, 2 votes opposed. Sorry.
You getting tired already?
Apparently I did. I had coffee.
With that, the motion passes.
All right, so now we're on to section B, which has 2 items. One is a leftover item from last year. Last year, the targeted misdemeanor list was changed to add non-existent crime 609.749 obscene or harassing telephone calls. The commission assumed that the intent was 609.79 obscene or harassing telephone calls, which actually is a misdemeanor with that name. There are no misdemeanors in 609.749. So that was actually one of the commission's recommendations to the legislature, as you may recall, and the legislature did that. They followed the commission's recommendation and corrected the list. The targeted misdemeanor list is used in 2 ways in the sentencing guidelines. One is targeted misdemeanors are the only misdemeanors that can contribute to the criminal history score, and being on probation for a targeted misdemeanor will qualify you for some sort of custody status. So that's item number 1B1, and then item number, and then the recommendation then is to update Appendix 4, which contains the targeted misdemeanor list. It's a pretty short list. It's right here. It's in statute. Its statutory function is booking. So if you're arrested for one of these offenses, you have to be booked. Otherwise, typically you don't have to be booked on a misdemeanor. So, but the commission basically is taking that list and doing double duty with it. The other item under B is renaming a felony offense. So there's an existing offense of, well, it's a misdemeanor to enter or be present in on the Camp Ripley Military Reservation, which is right in the center of Minnesota, without permission of the Adjutant General, who's the person who runs the Minnesota Department of Military Affairs. That offense becomes a felony if the trespasser, knowing that there's a risk of death, bodily harm, or serious property damage created thereby, is present in an area posted by order of the Adjutant General, is restricted for weapon firing or other hazardous military activity. So basically, if you're like downrange on a live fire range, you're committing the felony in addition to being very stupid. So, so that's an offense that the commission has ranked at severity level 3. So the statutory change then is to get rid of the restriction that it be at the Camp Ripley Military Reservation. The misdemeanor is expanded to cover all state and federal military lands and buildings, but the felony still has that restriction that the restriction be issued by the Adjutant General. So it's probably just limited to Camp Ripley. I'm not aware of any other live fire ranges that are administered by the Adjutant General other than Camp Ripley. I asked a guardsman that I talked to over the weekend about that, and he couldn't think of another.
Or he couldn't disclose it to you.
He couldn't disclose it
Right.
to you. Hopefully not. But anyway, that's so I don't really think there's an effective change to the statute. Really, we're just recommending a change to the offense title. No change to statutory maximums or other elements that would make it more or less severe. So that's the recommendation. Is just offense title and other editorial changes.
Is that the sum total of all the?
That's all of section B.
Part B?
Yep.
I'd entertain a motion to approve the changes in Part B. Commissioner Reeves makes that motion. Do we have a second?
Second.
Commissioner Larkin seconds. Any discussion on the motion? Hearing none, we can vote on that.
To the Reeves motion to adopt the staff recommendations as stated in Part B of the 2024 modifications document. Larkin?
Yes.
Larkin, yes. Crutchfield? Crutchfield, absent. Fraze?
Yes.
Fraze, yes. Knutson?
Yes,
Knutson, yes. Ladd?
Yes.
Ladd, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Moran? Moran, yes. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena? Saxena, absent. Miller? Mitchell, sorry.
Yes.
Chair Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
That is approved unanimously. So
That's-
just to clarify for everyone on the commission, the next step is that this package goes to public hearing. That is the July 18th date that was mentioned earlier. There's not a quorum required to be at that hearing, but I would encourage you all to be there. And then a week later, we come back and we can do a final vote on these decisions. Commissioner Larkin.
What time is the public hearing and where is it? Do we know?
1 p.m. at the Senate Office Building, room 1100.
1 p.m. at the Senate Office Building, room 1100. I heard that correctly.
So the Minnesota Senate Building is just directly across the street from the Capitol, across University from the Capitol, so.
All right. Oh yeah, I guess I have to move this on, don't I? Pull up the agenda.
Phrase.
Okay. My first question, what about the things in your area?
Well, we moved that move that after Richard, just in case we.
Right, is there anything that you would, how much time can you use?
No, I'm bumpable, but, or maybe we could just, honestly, we don't have that much time for Professor Fraze, so, we could just, I don't know how
Well, I'm
Professor Fraze
thinking,
would feel.
Professor Fraze, I'm thinking that we start your session today, but we have limited time, so do you have like a good stopping point? If you could get through a certain section, would that work for you?
Well, I told Nate that I know I can get through the slides themselves in less than what was the originally target 1 hour, but that would leave no time for questions. I don't really know if there's a good starting point, although I suppose there are about 3 different sections. One is what's the impact of criminal history. One is what are the justifications for the enhancements, and what are the problems. That's 3, and number 4 was what are possible solutions. So they all kind of fit together and build on each other. So I'm not quite sure what you want to do.
Probably could fill up the rest of the agenda just with our stuff, if Richard would be okay bumping his.
So would your preference be to do that at our next meeting where you can put it all together, or would you like to do a portion of it today? I guess, because I think we could do it either way. We can either probably give you 30 minutes today, or we could move the whole thing to the next meeting, whichever you think makes the most sense.
Okay. Yeah, I don't.
Commissioner Larkin might have a suggestion.
I don't want to bump you from the agenda, but I think what Professor Fraze has to tell us is very important.
Yeah.
And it might be the first time people are really hearing information that kind of is the background for stuff that they've been doing all along without thinking about it. And I'd hate, I know that if we hear 30 minutes and then we come back in 30 days, we're going to need to repeat the 30 minutes. I'd rather do it all at once. I think that would be most beneficial if Professor Fraze is willing to get bumped.
Yeah, so if we're talking about the July meeting, or
I think we'd be talking about the July meeting.
That's the week after the hearing. Does that meeting, presumably that meeting will also address any modifications based on the input at the hearing? So there will be work to do at that hearing. Although, again, if there's a shortage of time, it could be broken up and there'll be less of a gap between July and September than there is from June and September. So, I'm fine with putting it all off till next month. I'm also fine with sort of previewing the issues to sort of start warming people up. But as Judge Larkin points out, then we might have to repeat some of that the next time just to get it back in people's minds.
I don't know, people. What do you want?
And by the way, I will say, I wish I were there with you, but I'm not there with you to protect you from COVID. Because I got a positive test 8 days ago and I shouldn't be with you. So by July, I assume I will be with you.
That's wonderful. I'm glad, you don't look like you're feeling too bad, and so I'm glad that that's.
Oh, well, this is my stunt double.
Oh, there you go. Commissioner Ladd, did you have a comment you wanted to make?
I did, and I would just echo what Commissioner Larkin has said about sort of breaking it up. I think it's good to have it all together. I also recognize that we've got, a few people that are missing today as well.
Mhm.
So even if we did a preview the next time, I sort of feel like we would be revisiting that first chunk to get them up to speed for us to take off. So it does seem, from a comprehensive perspective, to have it all together. And as we've lived on this commission and we've debated this particular topic, I think it's really good that we have a focused time and energy toward this topic that's not bifurcated. That would be my preference.
Okay, I think that makes sense. So Commissioner Frades, if you'll indulge us, we will ask you to come back in July. I don't think the rankings will take as long in July. I see that we have, based on how things went today, we have one potential issue that we might need to discuss more, or that there could be further input on, more likely. And so but that won't take as long as the whole package. It seems like most of it we have agreement on. Before Commissioner Moran, I'm sorry, did you want to say something?
Oh, I just wanted to just echo what Commissioner Larkin was saying, or Commissioner Larkin was saying about it. As somebody who has continued to learn this in the process, I would like to have the ability to hear it all at once so I can put it all together. That's just my preference, but whatever is best for the commission. I was just trying to, as it seemed you were going that way, I took my hand down, but that's what I was going to say.
Gotcha. That sounds good. Thank you. All right, so that's what we will do. We will reserve the time in July, and but hey, Commissioner Frades, you have it all ready to go now. You can relax for the next month.
But I'll be tempted to tweak it. I will resist the temptation. I'll tie my hands and my fingers.
I'll be getting 2 hours instead of 1.
Yeah. All right, sounds good. Okay, so then we'll move on to, there's a whole bunch of stuff in the executive director's report section, so we'll move on to that.
Well, actually, I had a
Was there something
separate
else?
agenda item.
Oh, I'm sorry.
Also on the topic of, and maybe
Maybe we
this was
have to
going to
remove
be an
that.
overview of Minnesota's criminal history policy. Do you want to? I can just do that right now. Or,
I think we should put it all together. I thought,
It would all be together.
yeah, let's put that
Oh.
on next time too.
okay. All right. So we'll. Okay, so that gives us, that brings us to the executive director's report then, Madam Chair?
Yeah.
All right. All right, so the first thing I wanted to talk about was other laws that we don't think you're going to need to vote for. Present that. It's called Other Laws of Interest to the Commission. Now, the first 4 of these, I hope makes you feel good as the commission, because these are 4 of the 7 recommendations that you made to the legislature last year. And the legislature listened to you, and they adopted all 4 of these, and a 5th one that we've already discussed with respect to the targeted misdemeanor list. So number 1 is applying the 5-year probation cap exceptions to attempts. Basically, when the legislature copied the commission's list of offenses that were accepted from the general 5-year probation cap that was found in the sentencing guidelines, it didn't add attempts and conspiracies to that list. Which the commission wasn't the commission's intent. So the commission recommended that they add that. So they did add the homicide and attempted homicide and sex offenses to that list as you recommended. The second was really a typographical error in for juvenile or repeat or heinous sex offenses. There was a bad cross-reference. It said subdivision 4B, but it was subdivision 4B in an entirely different statute. So they fixed that. The third, this has been going on for a few years now, but they in 2021, I believe, they changed a number of age thresholds across various sex-related statutes, but they missed one in the child prostitution offense, which the commission caught when it was reviewing the child prostitution offenses, and so the legislature fixed that. And finally, there was first-degree witness tampering was on a violent crime list, but aggravated first-degree witness tampering, which is more violent than first-degree witness tampering, was not on the violent crime list, so the legislature added that offense. So that leaves two recommendations that are outstanding from the commission's 2024 legislative recommendation list. One is, so we recommended that the commission complete this mandatory life sentence in the pre-sentence investigation statute. So basically, a sentencing worksheet is required for any felony, but there are some felonies where there's not much point in doing a felony sentencing worksheet because there's only one legal sentence, and that's life in prison. Nevertheless, though, the statute, because the Sentencing Guidelines Commission is the clearinghouse and information center for felony sentences, the statute does require that the courts forward a sentencing worksheet, even in life sentence cases, to the Sentencing Guidelines Commission so we can have a complete record of the felony sentences in a given year. But instead of just saying life sentence cases, it lists all the life sentence statutes, but it misses one. It doesn't list the first-degree murder of an unborn child on the mandatory life sentence offense list. Not really sure why that's not there. Not really sure why the legislature didn't fix it, but it didn't get fixed. The other one is a little bit thornier of a question, and I almost wonder whether this shouldn't be referred to another body. Like, I'm kind of looking at the public defenders and the prosecutors over there. If there's not like, if somebody shouldn't look at this and figure out an actual recommendation, because the commission's recommendation was just this is broken, fix it, but we didn't actually say how to fix it. And this has to do with the crime of deprivation of a vulnerable adult. There's no degree of harm that's required in the elements of the crime, but the penalty provisions assume that there's either substantial or great bodily harm that resulted. So it's pretty confusing because the penalty and the elements don't match each other. There's an open question and confusion in the field as to whether substantial or great bodily harm is or is not a necessary element of deprivation of a vulnerable adult. And that could use some clarification. And, frankly, we don't know how if there is such a thing as deprivation of a vulnerable adult not resulting in substantial or great bodily harm, we don't know how it's ranked because the commission only ranked the two penalty provisions that exist. So that's a little bit messier. I mean, it's probably not a big enough issue for a whole task force or anything, and I don't know if it's worth the commission's time to address it, but it just kind of seems like something that maybe the Criminal Law Committee of MCAA or somebody could look at and come up with a specific recommendation. All right, so moving on then from the commission's recommendations, number 5, you heard the author of this bill talk to the commission, and that is that this is a new duty that has been imposed on your staff. We have to, the courts have to report to us, and we have to report to the legislature data pertaining to certain outcomes of deferred sentences under the Veterans Restorative Justice Act. The author came and spoke to you in April, and you unanimously supported this bill, and it was passed. Number 6, I kind of did a little behind the scenes work on this bill, requiring sentencing hearings for revoked stays of adjudication. This was in response to a Court of Appeals decision that said that 6914 does not apply to revoking a stay of adjudication. So the legislature changed 6914 so those processes do apply to a stay of adjudication. Sort of the tweaking that I advocated for behind the scenes is that they clarify what happens if a stay of adjudication is revoked. And that's kind of an issue right now, because right now the guidelines say, and it is the law, that if a sentence is pronounced immediately after a stay of adjudication is revoked, that the guidelines are then to be applied at that point. And the problem that you have sometimes as a judge, you know, like this is the 15th time I've seen you, you know, I'm revoking the stay of adjudication, I'm sending you to prison. Well, timeout, at that point, the guidelines have to apply. So if you're gonna do an aggravated departure, you have to do all the processes that normally apply to an aggravated departure. So that is sometimes misunderstood, and it's now been clarified in the law that you have to have a sentencing hearing, and that sentencing hearing involves a sentencing worksheet and an application of the sentencing guidelines. The seventh item here is modifying the predatory offender registration list. The big change is that false imprisonment was deleted from that list. It was probably the least predatory offense on that list, so it's now gone. Another change on 8, limiting, also dealing with predatory offender registration. So currently, if somebody is on the predatory offender registry, you know, they're on there, say 10 years, and then they're going to get off. Well, if they get incarcerated after a conviction or a probation revocation on any new offense, that restarts the registration period. So any incarceration for any offense, as long as it involves a conviction or a probation revocation, restarts a brand new 10-year registration period. You know, that can be a big deal for somebody who spends a weekend in jail on a disorderly conduct. All of a sudden, you know, maybe they were almost done with registration, they have to restart. So now the law says that the offense of incarceration must itself be a predatory offense. So that's a significant limitation on those restarting offenses. And number 9, we really talked about last year. That's amending the trigger activator crime to include binary triggers. This is an offense that the commission just ranked at severity level 8 in 2023. We didn't see this as changing the elements substantially enough that the commission would be interested in re-ranking it or revisiting its ranking decision from last year. But you certainly could. That's just how staff saw it. If you see it differently, take a look at that. But I'm not going to get into that because we talked about binary triggers last year. Number 10 was banning the panic defense, basically the idea of that you might have a defense to use of force, for example, based on sudden learning about the victim's actual or perceived sexual orientation. That's explicitly not a defense. Just for your information, when we did the fiscal note on this a couple of years ago, we didn't find any evidence that there was such a defense in Minnesota. So we didn't say that this had an impact repealing the defense. And that's it. So that's I guess the first item on the executive director's report.
Any questions from anyone on those? Commissioner Reeves.
Not necessarily a question, but a comment. I am super excited to see number 8 as a level 3 predatory offender supervising agent in the county. This makes me very, very happy. It makes my job much, much easier. So I'm glad to see that. But I am curious though, was there conversation, because there are some offenses for some reason, if they go in custody for a day, that was restarting registration. So was that clarified as well in this new statute?
No, it's still a day. A day will still do it as I understand it, but it's just that the offense can't be disorderly conduct anymore. The offense has to be a predatory offense. So you have to be convicted for an offense that's on the predatory offense list. And if you're in jail for a day on that, it's still the rule that restarts your 10-year clock.
Other questions? All right.
So the second thing I wanted to share with you is the demographic impact statement for Senate File 3663. Now I'm a little bit excited about this, which I hope you'll bear with me. Not asking you to share my excitement, but so this is. Let me just say, this bill did not go anywhere. This bill did not end up getting enacted. So that's not why I'm excited about it. But I'm just excited about the fact that we were able to. I'm sorry, I'm having difficulty sharing my screen. There it goes. So it was a bill that basically would have said that trace amounts of drugs do not equate to felony possession of a controlled substance. And honestly, the legislature already made a significant change in this regard last year with very little fanfare, but this would just kind of complete the job. What's interesting about this demographic impact, well, I'm providing this demographic impact statement to you because one, your policy says that we provide it to you unless, and it really doesn't become technically final until this meeting's over, because you have the opportunity to say, we don't like this and we're gonna, I guess, ask for it to be withdrawn or whatnot. What's I think interesting about this is there's two changes that we made here in the style of how we do demographic impact statements. So one is in the two tables, table 2 and table 3, that actually show the impact. Where we have, so the structure of this is we have the existing felony population. So this is impact in terms of the felony population. Table 3 is impact in terms of prison population. We show the existing felony population, the estimated change, the estimated annual felony population, including the rate per 100,000. So we've got the before and after rate per 100,000. This column here, change in rate per 100,000, is new. And this is based on some scholarship that Professor Kevin Reitz, who the commission's well familiar with, has done. And he essentially advocates in these papers for this being really the most important, or at least a very significant, if not the most important statistic in terms of policymakers and looking at changes in policy that will change imprisonment rates. Is this change in the rate as being the most important change? And if you look at these changes, you know, it kind of sticks out at you that the American Indian Group has the highest change in rate per 100,000 as a result of this bill, and the 9th Judicial District also has the highest change in rate per 100,000. As far as the felony population goes, and the next table, you see a similar thing, lower numbers because you're talking about prison population, which there are obviously fewer prisoners per 100,000 than felons per 100,000 in a given year. But also the American Indian Group had the largest change in rates. And I feel like Professor Wright's scholarship freed us up to sort of gave me a basis anyway, for saying, okay, this is an important number. Of all those numbers, we can emphasize that number. So, so on the front page of the demographic impact statement, we have information about the absolute change in rates, and we emphasize that the American Indian Group saw the biggest change, both in terms of felony sentence rate and the imprisonment rate, significantly larger change than you saw among felons and prison beds overall. And in judicial districts, 9th had the largest changes. So I think what this does as a practical matter is it gives something that a busy legislator can sink his or her teeth into on the front page without having to dive through a bunch of numbers and tables that really don't add a lot of value. So I think this change, which I have to give Professor Wright's credit for, not that he suggested the application of it in our demographic impact statements, but just his work in the scholarship of this will really make demographic impact statements more useful going forward. The next, unless there are any questions on that, I'd like to call up Leah Bauer to give the next item in our presentation.
Sure. No, I would just say thanks for continuing to look at the demographic impact statement and to continuing to find ways to improve how the information is presented and make it more clear what the demographic impact really is of these law changes. So I just want to say that.
All right. All right. Just a real quick update. If you remember back in the March Commission meeting, Director Wright talked about missing sentencing worksheets and a memo that went out to probation officer, probation staff about that starting in this year, worksheets not completed by probation agencies will appear as missing data. If you recall, Director Wright
talked about how MSG staff had made up missing worksheets, and we're no longer doing that. And so since that time, we have, staff have been meeting with a variety of organizations. We met with DOC, we met with the MACAC Board of Directors, we met with Hennepin County, we've met with Scott County to really talk through the missing worksheet kind of issue, to hear from staff what problems they're having with maybe the electronic worksheet system, if there's anything we can do to kind of improve that process so we don't have missing worksheets. We also are going to be meeting with Dakota County next week, and we're more than happy to meet with anyone who has any questions about missing worksheets or has feedback on the process. Our real goal is to get to 0 missing worksheets at sentencing. I mean, we can strive for that, and this has been, it's been really helpful to talk to different agencies and hearing about the process. So that's my updates. Again, if anyone wants to know more about that or would want us to come talk to anyone about the process or issues they're having with entering worksheets and getting them to judges by the time of sentencing, please let us know.
Commissioner Lett.
Thank you. Just at a high level, are you identifying any themes or sort of barriers to why this problem is even occurring in the first instance?
We are. I'm not quite ready to
Okay.
put those together, but our hope is to compile that. And I think also with, Matt is doing public engagement, right? And they are meeting with probation officers. And we're thinking that one of the things they're going to hear from that probably has something to do with the missing worksheets and the process of entering that information. So we're hoping to compile all that information. We've been taking notes from every meeting we've had, and we are learning some really interesting things. So we hope to bring that back.
So is it safe to, sorry, Madam Chair, if I might, is it safe to say that these larger counties that you've named are sort of sources of where you're seeing some patterns and trends?
Yes, that's safe to say. But there's some real reasons for that makes
Sure.
sense. So I think part of it's problem solving on our end too, and hearing where our system might need to make some improvements or adjustments as well. So it's a great learning experience. There are some pain points, and like I said, we'll hopefully come back and be able to share that with you. Yeah, and it's been great to work with Hennepin because they're our biggest user, right? And to kind of, we have some follow-up conversations, so we may be able to address some of those issues moving forward.
Commissioner Knudsen.
I thought we weren't gonna name names. But what is the issue with Sky Dakota? I mean, just general. Are they not?
You want to say some of the issues? Some of it has to do with, criminal history and how they're using the electronic worksheet system, and whether they're using that system to bring criminal history and the worksheet to sentencing or not, or they're using something different. So that's one issue. I think some things we're hearing are, PSIs aren't always ordered in felony cases. And so sometimes those are slipping through the cracks. And again, I want to just say this is very preliminary. So I don't want, just take it with a grain of salt. There could be cases that are slipping through the kind of cracks because that PSI wasn't ordered. And I know there were a lot, particularly in Dakota, but I think also in Hennepin counties that the PSIs aren't being ordered. So I think there's some of those pieces, but I think we can bring a more comprehensive list and be potentially an interesting discussion to have moving forward.
Commissioner Knudsen.
But it's a big outlier? They're big outliers compared to the other 87 counties?
I plead the fifth. I'm not going to say any more right now until we have all the information, because I don't want to misstate anything. And I do want to say that everyone.
Let me save you. Let me rescue you and just say this. I was in on the DOC conversation. We have the tiniest counties in the state, and yet the same types of issues happen there too. So it's not about the fact that a particular county isn't doing it right. It's that there are common workflow issues that all counties are experiencing. And some of them are just bigger, so the problem looks bigger, but it's the same workflow problem. And that's what they're trying to get to the bottom of, is what is that workflow and how can we improve that?
Kind of those pain points in that workflow or the implementation of the sentencing guidelines. So, I don't want to point out like that anyone's they're not doing something on purpose. I think because of practices and again, workflow, and different jurisdictions look a little different, and how well, our EWS system is working with their processes. It looks different, and there are different pain points in different jurisdictions.
Thank you.
Any other
Thank you, she
questions?
says.
Okay, thank you very much, Leah. What's next on your list?
Okay, so the National Association of Sentencing Commissions 2024 conference, the registration's open. Anybody's welcome to go. It's August 6th through 8th, 2024 in Raleigh, North Carolina. As far as the commission's funding it, so based on my little algorithm that I have, it's you go to the bottom of the pile once you've been offered to go. So the people that we will be offering to are basically going to be coming from the new commission pile this year, just to let you know. So expect an email within the next day or two from Linda, just kind of letting you know if you are on that list, and just let us know whether you want to come. So
How many are you able to send this year?
you know, it's a fair amount. We had some salary savings this year, so it's going to be a little larger of a contingent. I'm just going to leave it at that for now, because a lot will depend on ultimately who says yes and that sort of thing. I will say that Commissioner Moran has been, we are going to be offering him the funding for the registration only, because another group wants him on a panel of basically because he's in a new seat, and Minnesota's not the only commission that's created a seat like his for somebody who's formerly been convicted of a felony and served his sentence. So that's so they're going to be funding the transportation and lodgings. We're happy to see those dollars matched and multiplied by another entity. So we'll be offering him registration for the conference, and others. It will also include lodging and transportation.
Commissioner Reeves.
Thank you, Madam Chair. Can you remind us of the dates?
It's August 6th through 8th, and that'll be in the email.
Thank you.
All right, any other questions, comments?
And then the final item on my update has to do with staffing and membership. So as far as membership goes, I know that I haven't heard from the governor's office where they are in the process of replacing or appointing the successor to Commissioner Morath. But I do know that according to the Secretary of State's website, there's one applicant for that position so far. And that position is a public member seat that does require this person have been a victim of a felony crime.
Or an advocate.
Or an advocate, thank you. That's a change. I forgot about that. Yep. So you can also be an advocate. And as far as membership goes, the agency is now fully staffed at 7 FTEs plus 1 temporary FTE for a total of 8 FTEs. And the newest addition, I'm pleased to introduce all the way from the state of Alaska, research analyst intermediate Andrew Gonzalez, who started May 15th. Thank you, Andrew. Welcome. So pretty exciting to see our at our staff meeting, our conference table, which seats 8 people, fully filled out. So
The new guy has to bring the donuts?
Actually, Leah brought the donuts from Winona, and I had a bacon maple donut for the first time in my life, and it wasn't nearly as bad as I thought it would be. It was actually delicious. Yeah, it was pretty good. Madam Chair, that more than concludes my report.
Okay, there's one more on here, the Administrative Rules Subcommittee update. Is that Commissioner Knudsen?
We have been meeting and fly specking and wordsmithing, some modifications to Minnesota Rule 3000, which governs the procedural operations of the Minnesota Sentencing Guidelines Commission. And basically what we're looking at is trying to provide more clarity to allow us to move a little quicker with respect to proposals and then public hearings. And in response to the timing of the legislature, give us a little more flexibility. And then also in the methods and how we inform the public of our actions. So I really want to thank our other members, Commissioner Middlebrook and Commissioner Moran, and particularly staff and our director, Wrights, which setting the stage, there was a lot of work done over several years. It's just kind of been building up what needs to change, what do we really understand what those procedural rules are, and then how to make them work better for the work we want to accomplish. So we're hopeful, Madam Chair, that we will have something within the next month.
Great. Awesome. Any questions from anyone? All right. Seeing none, then I think we're on to public input.
Oh, yeah. Okay, so members of the public, it looks like all of you are on via computer. So if you, you should be have a WebEx application that allows you to raise your hand. That on my computer looks like a little hand icon down at the bottom of the screen, right next to the record button. It may look different. If you would like to make a public comment to the commission, you can do so at this time, but you have to raise your hand. So please press the hand button. Oh, and there are also people in the room today, which is honestly not been the norm since COVID. Our in-person attendance has gone down. So if anybody in the room would like to make a statement to the commission, you can also raise your hand.
Okay. All right. Why don't you come on up to the front here, and you can make your statement here. It looks like I'm not seeing anyone online that wants to make a comment.
Yeah.
Okay.
Up to the front where?
Just right up to the front there. And when you start, just state your name for the record. And
Okay, do you want me to stand or?
Yeah,
you
no,
can sit down.
Oh, I can see.
Okay. Yeah,
It's like, good.
yeah, no, that's fine. Just state your name and then start whenever you're ready.
Okay, my name is Kathleen Farron. Kathy is what I go by. I've been doing a lot of learning about the sentencing guidelines and criminal sentencing. And I found a lot of really disturbing information online with law enforcement and them altering offenders' names. It's really easy to see, actually. You can go online to Minnesota, it's public access courts.mn.us. And they are not spelling the names of offenders correctly so that they can avoid sentencing them within the sentencing guidelines. And I actually have like a bunch of proof actually over my purse. It's really, really bad. And I don't know, I feel like probably there's gonna be a lot of people that know about it. I mean, like, take for example, a person's name is Robbie, Robbie. Instead of spelling it Robbie, they spell it Robby, so that they can sentence him less, you know, it won't be an automatic commit to, they can give him probation or like a stay of adjudication or a stay of imposition. Spence Edwards, it's a father and a son. He's a Roman numeral 4. It's like the 4th one. They will actually take and put the Roman numeral in the middle of the name as opposed to at the end of the name. And that makes it a new person. They can offer him, or they just remove it altogether, and he's just Spence Edwards. I mean, it's in so many criminal records. It's absolutely insane. They're just, and then they don't file the charges. Many times they're not filing, like if you look at Spence Edwards' criminal history, they aren't filing the charges, I mean, for 6 months. And then when they do finally or file the charges, it takes a year, year and a half. Hundreds of pages are filed just so that for a gun charge that he should be going away for 5 years. I know that it's 30, whatever, the 2/3 of that. He doesn't go away. He gets a stay of imposition, or he gets a stay of execution. He got 2 stay of impositions. One for 5th-degree drugs where he had 69 grams of marijuana. And in this drug or the gun charge that he got stay of execution on, he was caught with like 3,500 grams of marijuana and a gun. And he got house arrest. And I mean, and the $10,000, I think it was $10,000 or $11,000 cash, I can find absolutely no record of it. Oh, wait, no, that's the one I can find a record of. Oh, they dismissed the case. And so he got his money back. Why would you dismiss? You found over 3,000 grams of marijuana. They went through all the work of raiding his house and his apartment, his friend's apartment, or his girlfriend's apartment, and they gave him back the $10,000. Oh, and then his public defender fee for $75. He doesn't have to pay that. He still hasn't even paid. They gave him the money back, allegedly, just days after his sentence, state sentence. And he still hasn't even paid his court fees or fines of $120 some. Another person, Holly Faulkner, she had 3 of the 1st-degree sale of narcotics. She was caught with like 600 and some grams of methamphetamines, and they're not filing the charges. And again, $11,000, I can find no record of that one. I can find no record of, except for maybe they put $2,000 into the whatever, the forfeiture. And so I just don't understand, like, the sentencing thing. People are dying. I mean, Daniel Marcel Shepard, they didn't put him back in prison when he was beat and robbed a man. They didn't file the charges for, let's see, it happened in May of 2019, and they didn't file that until March of 2020. He got caught with a firearm. He's a violent offender. They didn't file that charge for a few months. They let him get out. I mean, he shot a man 3 times and they did nothing, absolutely nothing. They let him be on the streets for, 2 months. I mean, it's like, well, he beat and robbed a man and you're not doing anything about it. He didn't register. He's a predatory offender who apparently had a 1st-degree sex or criminal sexual conduct before 18, so I can't see that. I mean, he stole my car on the 29th of June, and I mean, all of it, they do nothing. Of course, what is the next thing that he's going to do? If he keeps getting away with it, what's the next thing he's going to do? He kills a man. That is a person that is dead because the police did nothing, absolutely nothing. And I asked a police officer, why isn't Marcel in jail, in prison? Why isn't he locked up? He shot a man 3 times. Oh, if it's our understanding, Nate was the guy's name, he hasn't been very cooperative. He did it in the middle of the street, in broad daylight. A bunch of people saw it. They didn't even arrest him. He was already, they had charged, and then in the case where he beat and robbed a man in Ramsey County, they decided to charge him with kidnapping. Nothing in the complaint says anything about kidnapping. And I know the plan was probably to get it dismissed because there is nothing to say that it was kidnapping. But then once he killed the guy and then it came, well, they figured, well, as long as he killed somebody now. So now we're going to have to find him, hold him accountable. So now we'll put him with the charge for the shooting the man 3 times. Oh, all of a sudden we know who he shot this guy, and run all the sentences concurrent. He's going to be out in 2028. I had a person tell me what happened when he shot that man. The guy was being rude and disrespectful to Marcel, and Marcel pulled his gun out put it up against this guy's abdomen, pulled the trigger and killed him. And then said, now lay down and die. And that's all he'll be out in 2028 because shooting a person 3 times and then killing a person, beating and robbing a man, that's not that big of a deal. Do you think that he's going to do it again? I'll tell you right now, I met the man. He will kill again. He is a dangerous, dangerous individual. He does not care. He told me he had a gun. I didn't want to hang out with him, but I got dumped off because the person didn't want to be with him. And I didn't know anything about anything. And he's a quite scary person. And, but he had a gun the whole time, even though he's prohibited from carrying a firearm. And he told me that if anyone steps to him, he's pulling the gun out and he's shooting first. He's not asking questions, he's shooting. I don't know if you guys get to know the perspective of what it's like, but they are letting people go that are hard, they're very dangerous criminals. And they are committing heinous crimes against people. And this is, people are dying, and it's very serious. It's very serious.
Madam Chair,
Commissioner Knudsen.
thank you for bringing this to us. I'm wondering have you talked with the county attorneys about this or pointed some of this out to them?
With my investigating or that, I am not well liked by anybody. I was set up in South Dakota. They have police officers, and this guy that I was dating that I kind of fell in love with, that's a criminal, tricked me into going to South Dakota so he could say goodbye to his dying uncle so that he could hide drugs in my door. And they took my car. They won't even give me a trial to fight for it. So, no, I don't think that it would be, I don't think that they would really care to hear any of it, because I mean, like, they have came after, prior to that, my car had been stolen 7 times. My car had been crashed. I mean, they had a gun pulled on me. They're going above and beyond to, destroy my life. So.
Well, thank you for talking to us today.
So, I mean, I would love to send you something there just to show you, like, but, yeah. Man, maybe you guys already know about it. All right.
Thank you for
I had to
coming
try.
in today and sharing your story.
Mm-hmm. Yeah.
I think there was no one else online who was interested in doing public comment today. Is that correct?
That's correct, Madam Chair.
There being no further business, unless there's any objection, then the meeting is adjourned. We'll see you twice in July, right? Yeah, twice. Have a good rest of the month. Thanks.
Thanks.